Part 3. The Executive Department. Letter A. Nature of Executive Power. Number 1. In relation to the implementation of laws, including delegated powers. And number 2. Express or implied, including the faithful execution of laws and residual powers. Powers of the President. Besides the Constitution, the powers of the President of the Philippines are specifically outlined in Executive Order No. 292, 1987, otherwise known as the Administrative Code of 1987. The following powers are: number 1, power of control over the executive branch; number 2, power ordinance power; and number 3, power over aliens; number 4, powers of eminent domain, escheat, land reservation, and recovery of ill-gotten wealth. Number 5, power of appointment. Number 6, power of general supervision over local governments. Number 7, other powers. Etong power of let's go back to the first power, which is the power of control over the executive branch. The President of the Philippines has the mandate of control over all the executive departments, bureaus, and offices. This includes restructuring, reconfiguring, and appointments of their respective officials. The Administrative Code also provides for the President to be responsible for the above-mentioned offices' strict implementation of laws. Then the second power, ordinance power. The President of the Philippines has the power to give executive issuances which are means to streamline the policy and programs of an administration. There are 6 issuances that the President may issue. They are the following as defined in the Administrative Code of 1987. Executive orders, administrative orders, proclamations, memorandum orders, memorandum circulars, general or special orders. The third power of the President is power over aliens. The President of the Philippines has certain powers over non-Filipinos in the Philippines. The powers he may exercise over foreigners in the country are as follows. The Chief Executive may have an alien in the Philippines deported from the country after due process. And the President, another power of the President over aliens is that the President may change the status of a foreigner as prescribed by law from a non-immigrant status to a permanent resident status without necessity of visa. The President may choose to overrule the Board of Commissioners of the Bureau of Immigration before their decision becomes final and executory after 30 days of the issuance of the decision. The Board of Commissioners of the Bureau of Immigration has jurisdiction over all deportation cases. The President is also mandated by the Administrative Code of 1987 to exercise powers as recognized by the generally accepted principles of international law. Then the fourth power is powers of eminent domain, escheat, land reservation, and recovery of ill-gotten wealth. So the President of the Philippines has the authority to exercise the power of eminent domain. The power of eminent domains means the state has the power to seize or authorize the seizure of private property for public use with just compensation. Next is the President also have the power to direct escheat or reversion proceedings. The President shall direct the Solicitor General to institute escheat or reversion proceedings over all lands transferred or assigned to persons disqualified under the Constitution to acquire lands. Next is the President has the power to reserve lands to the public and private domain of the government. So the President shall have the power to reserve for settlement or public use and for specific public purposes any of the lands of the public domain, the use of which is not otherwise directed by law. The reserved land shall thereafter remain subject to the specific public purpose indicated until otherwise provided by law or proclamation. Number 2, he shall also have the power to reserve from sale or other disposition and for specific public uses or purposes any land belonging to the private domain of the government or any of the freer lands, the use of which is not otherwise directed by law, and thereafter such land shall be used for the purposes specified by such proclamation until otherwise provided by law. The President also has power over ill-gotten wealth, so the President shall direct the Solicitor General to institute proceedings to recover properties unlawfully acquired by public officials or employees from them or from their nominees or transferees within the period fixed in or any extension thereof authorized by the Constitution. The President shall have the authority to recover ill-gotten properties amassed by the leaders and supporters of the previous regime and protect the interests of the people through orders of sequestration or freezing of assets or accounts. Number 5. The President has the power to appoint. So the President may appoint officials of the Philippine government as provided by the Constitution and laws of the Philippines. Some of these appointments, however, may need the approval of the Committee on Appointments, a committee composed of members from the House of Representatives and the Senate of the Philippines. Number 6. The President has the power of general supervision over local governments. The President of the Philippines, as Chief Executive, has the mandate to supervise local governments in the Philippines despite their autonomous status as provided by Republic Act No. 7160, otherwise known as the Local Government Code. So traditionally, this is done by the Department of the Interior and Local Government headed by the Cabinet Secretary and alter ego of the President. Other powers. So the President exercises other powers. Aside from the aforementioned powers of the President of the Philippines, he can also exercise powers enumerated in the Constitution and powers given to him by law. Next concept is the express or implied powers of the President. So express powers are the powers explicitly granted to the President in the Constitution, while implied powers are powers not expressly stated in the Constitution but have been interpreted by presidents as necessary to faithfully execute laws and defend the Constitution. Residual. What are residual powers? So this concept of residual powers. The law says, unless Congress provides otherwise, the President shall exercise such other powers and functions vested in the President which are provided for under the laws and which are not specifically enumerated above, or which are not delegated by the President in accordance with law. This is Section 20, Chapter 7, Executive Order Number 292, or the Administrative Code of 1987. Jurisprudence says, according to jurisprudence, the power involved in President's residual power to protect the general welfare of the people, it is founded on the duty of the President as steward of the people. To paraphrase Theodore Roosevelt, it is not only the power of the President but also his duty to do anything not forbidden by the Constitution or the laws that the needs of the nation or the laws. It is a power borne by the President's duty to preserve and defend the Constitution. It also may be viewed as a power implicit in the President's duty to take care that the laws are faithfully executed. Marcos versus Manglapos, September 1989. Moreover, although the 1987 Constitution imposes limitations on the exercise of specific powers of the President, it cannot be said that the scope of the executive power is limited only to what the Constitution provides. The executive power is more than the sum of specific powers so enumerated. Marcos versus Manglapos, September 1989. What are the examples of the residual powers of the President? Number 1. The President's power to deport undesirable aliens, which may be exercised independently of constitutional or statutory authority because it is an act of state. The Supreme Court justified the action of the late President Aquino in banning the return of the Marcoses to the Philippines on the basis of the President's residual powers. Faithful execution of the laws. Faithful execution of the laws. So this concept is from the Constitution, where it says that the President shall have control of all executive departments, bureaus, and offices. He shall ensure that the laws be faithfully executed. So this is Article 7 of the Constitution. Article 7, Section 17 of the Constitution. Concept of presidential immunity. Discuss presidential immunity. The President shall have immunity from suit for official acts during his tenure. So the President shall have immunity from suit for official acts during his tenure. However, after his tenure, the Chief Executive cannot invoke immunity from suit for civil damages arising out of acts done by him while he was President, which were not performed in the exercise of official duties. Estrada versus Desierto, March 2, 2001. So, presidential immunity. The President shall have immunity from suit for official acts during his tenure. Romualdez versus Sandigan Bayan, July 2004. However, after his tenure, the Chief Executive cannot invoke immunity from suit for civil damages arising out of acts done by him while he was President, which were not performed in the exercise of official duties. Estrada versus Desierto. So the act is done by him while he was President, but it was not performed in the exercise of official duties. So in that case, the President cannot invoke immunity. Estrada versus Desierto, March 2001. Question: is a non-sitting President immune from suit? Answer: no. Non-sitting President does not enjoy immunity from suit, even for acts committed during the latter's tenure. The rule is that unlawful acts of public officials are not acts of the state, and the officer who acts illegally is not acting as such, but stands in the same footing as any other trespasser. The intent of the framers of the Constitution is clearly that the immunity of the President from suit is concurrent only with his tenure and not his term. Hence, the former President Arroyo cannot use the presidential immunity from suit to shield herself from judicial scrutiny that would assess whether within the context of amparo proceedings she was responsible or accountable for the abduction of Rodriguez. Case in the matter of the petition for the writ of amparo on habeas data in favor of Noriel H. Rodriguez versus Macapagal Arroyo, November 2011. Next, concept of executive privilege. Presidential privilege. Question: what is executive privilege? Etong executive privilege is the power of the President to withhold certain types of information from the courts, the Congress, and ultimately the public, Bernas Supra, Executive privilege is the power of the president to withhold certain types of information from the courts, the Congress, and ultimately the public. Question: what is the scope of this privilege? Presidential conversations, correspondence, or discussions during closed door cabinet meetings, like the internal deliberations of the Supreme Court and other collegiate courts, or executive sessions of either House of Congress, are recognized as confidential. This kind of information cannot be pried open by co-equal branch of government. Senate versus Ermita, April 2006. So the scope of this privilege: presidential conversations, correspondences, or discussions during closed-door cabinet meetings like the internal deliberations of the Supreme Court and other collegiate courts or executive sessions of either House of Congress are recognized as confidential. Question: what are the kinds of executive privilege? There are three kinds of executive privilege to wit. Number one, state secrets privilege. The information is of such nature that its disclosure would subvert crucial military or diplomatic objectives. Number two, informer's privilege, or the privilege of the government. Non-disclosure of the identity of persons who furnish information of violations of law of officers charged with the enforcement of that law. Number three, generic privilege. Privilege for internal deliberations said to attach to intragovernmental documents reflecting advisory opinions, recommendations, and deliberations comprising part of a process by which governmental decisions and policies are formulated. Senate versus Ermita, April 2006. So the three kinds of executive privilege are state secrets privilege, informer's privilege, generic privilege. Executive privilege. Who may invoke? Since the executive power belongs to the president, only the president can invoke it. Executive powers of the president, executive privilege. Executive privilege is the power of the government to withhold is the power of the president to withhold information from the public, the courts, and the Congress. Executive privilege is a right vested in the president, which she may validly exercise within her sphere of executive power. There are two kinds of executive privilege. First is the presidential communication privilege, and second is the deliberate process privilege. Executive privilege is the right of the president and high-level officials authorized by her to withhold information from Congress, from the courts, and ultimately from the public. Jurisprudence says, simply put, executive privilege is the power of the government to withhold information from the public, the courts, and the Congress. It is also defined as the right of the president and the high-level executive branch officers to withhold information from Congress, the courts, and ultimately the public. It must be stressed that executive privilege is a right vested in the president, which she may validly exercise within her sphere of executive power. The president can validly invoke executive privilege to keep information from the public and even from co-equal branches of the government. Example, the legislature and the judiciary. Romulo Neri versus Senate Committee of Accountability and Public Officers and Investigation, March 2007. Since executive power belongs to the president, only the president can invoke it. The executive secretary, as an exception to the rule, can invoke the privilege on behalf of the president. Jurisprudence says, Senate versus Ermita, April 2006. In the light of this highly exceptional nature of the privilege, the court finds it essential to limit to the president the power to invoke the privilege. She may, of course, authorize the executive secretary to invoke the privilege on her behalf, in which case the executive secretary must state that the authority is by order of the president, which means that he personally consulted with her. The privilege being an extraordinary power, it must be wielded only by the highest official in the executive hierarchy. In other words, the president may not authorize her subordinates to exercise such power. There is even less reason to uphold such authorization in the instant case where the authorization is not explicit, but by mere silence. Senate of the Philippines versus Ermita, April 2006. In invoking the executive privilege, it requires a specific designation and description of its scope. So, jurisprudence. According to jurisprudence, a formal and proper claim of executive privilege requires a specific designation and description of the documents within its scope, as well as the precise and certain reasons for preserving their confidentiality. Without this specificity, it is impossible for a court to analyze the claim short of disclosure of the thing sought to be protected. Senate of the Philippines versus Ermita, April 2006. There are two kinds of executive privilege. First is the presidential communication privilege. This is the kind of executive privilege applies to the decision making of the president and his staff and is rooted in the doctrine of separation of powers. Jurisprudence says presidential conversations, correspondences, or discussions during closed-door cabinet meetings, which, like internal deliberations of the Supreme Court and other collegiate courts or executive sessions of either House of Congress, are recognized as confidential. This kind of information cannot be pried open by a co-equal branch of government. A frank exchange of exploratory ideas and assessments, free from the glare of publicity and pressure by interested parties, is essential to protect the independence of decision-making of those tasked to exercise presidential, legislative, and judicial power. Chavez versus Public Estates Authority, July 2002. The second kind of executive privilege is the deliberative process privilege. The deliberative process privilege is lesser in scope than the presidential communications privilege. Its coverage and duration are limited. It stands to the reason that the privilege may be waived unless the information concerns national security, diplomatic relations, or public order. Jurisprudence says the deliberative process privilege is a privilege that an officer of an executive department may invoke to prevent public disclosure of any information that may compromise its decision-making capability. Its purpose rests most fundamentally on the belief that where agencies forced to operate in a fishbowl, frank exchange of ideas and opinions would cease and the quality of administrative decisions would consequently suffer. The purpose of the deliberative process privilege is to prevent subjecting an agency's decision-making process to public opinion before any definite policy action has been made. Going back to the first part of part 3 of the syllabus, which is delegated powers. So under the nature of the executive department, delegated powers. What are the powers delegated to the president? So the Constitution grants emergency powers to the president. Discuss the emergency powers delegated to the president. In times of war or other national emergency, Congress may, by law, authorize the president for a limited period and subject to such restrictions as it may prescribe to exercise the powers necessary and proper to carry out a declared national policy unless sooner withdrawn by a resolution of the Congress. Such powers shall cease upon the next adjournment thereof. So this is Article 6, Section 23 of the 1987 Constitution. Next, what are the conditions for the vesture of emergency powers to the President? So the following conditions must be satisfied before emergency powers may be vested to the President. Number 1, there must be war or other national emergency. Number 2, the delegation must be for a limited period only. Number 3, the delegation must be subject to such restrictions as Congress may prescribe. Number 4, the emergency powers must be exercised to carry out a national policy declared by Congress. Question: does the President have tariff powers? Yes, the President is granted standby or flexible tariff powers in the Tariff and Customs Code. The Congress may by law authorize the President to fix specified limits and subject to such limitations and restrictions as it may impose tariff rates, import and export quotas, tonnage and wharfage dues, and other duties or imposed within the framework of the National Development Program of the government. Residual powers. Discuss the residual powers of the President. So the President, upon whom executive power is vested, has unstated residual powers, which are implied from the grant of executive power and which are necessary for her to comply with her duties under the Constitution. The powers of the President are not limited to what are expressly enumerated in the article of the Executive Department and in unscattered provisions of the Constitution. This is so notwithstanding the avowed intent of the members of the 1986 Constitutional Commissions to limit the powers of the President as a reaction to the abuses under the regime of Mr. Marcos, for the result was a limitation of specific power of the President, particularly those relating to the Commander-in-Chief clause, but not a diminution of the general grant of executive power. Marcos versus Manglapos, October 27, 1989. Question: state examples of residual powers of the President. So the President has the residual power to forbid the return of her exiled predecessor Marcos versus Manglapos, October 1989, to declare a state of rebellion and to implement reorganization measures. Malaria Employees and Workers Association versus Executive Secretary, July 31, 2007. So, qualifications and term of the President. The President of the Philippines is elected by direct vote by the people for a term of 6 years. He may only serve for one term and is ineligible for re-election. The term of the President of the Philippines starts at noon of the 30th day of June after the election. Qualifications. So the qualifications for an individual aspiring to become President of the Philippines are outlined in Article 7, Section 2 of the 1987 Constitution. According to the Constitution, an individual may become president provided he meets the following criteria. Number 1, natural-born Filipino citizen. Number 2, a registered voter. Number 3, must be able to read and write. Number 4, 40 years of age at the day of the election. And 5, must have resided in the Philippines 10 years before the election is held. The rules of succession. What are the rules of succession if the vacancy occurs before the beginning of the term of the President? So, it occurs before the beginning of the term of the President. So, what are the rules of succession if the vacancy occurs before the beginning of the term of the President? The following rules must be observed in such cases. In case of death or permanent disability of the President-elect, the Vice President-elect shall become President. Number 2, in case of failure to elect the President, example, presidential election has not been held or non-completion of the canvass of the presidential elections, the Vice President shall act as the President until the President shall have been chosen and qualified for. Number 3, in case no President and Vice President shall have been chosen and qualified, or where both shall have died or become permanently disabled, the President, the Senate President, or in case of his inability, the Speaker of the House of Representatives shall act as President until a President or Vice President shall have been chosen and qualified. Congress shall by law provide for the manner in which one who is to act as President shall be selected until a President or Vice President shall have qualified. In case of death, permanent disability, or inability of the officials, mentioned herein. So, what are the rules of succession if the vacancy occurs during the incumbency of the president? So, the following rules must be observed in such cases. In case of death, permanent disability, removal from office, or resignation of the president, the vice president shall become president to serve the unexpired term. Number two, in case of death, permanent disability, removal from office, or resignation of both the president and the vice president, the Senate President, or in case of his inability, the Speaker of the House of Representatives shall act as President until a President or Vice President shall have been elected and qualified. So, what are the rules of succession when there is presidential inability to discharge the powers and duties of the President? So the following rules must be observed in such cases. Number one, when the President transmits to the Senate President and to the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, the powers and duties of his office shall be discharged by the Vice President as acting President. Or number two, when a majority of all the members of the Cabinet transmit to the Senate President and to the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. About the Vice President, um, again, Article 7, Section 3 of the 1987 Constitution says that there shall be a Vice President who shall have the same qualifications and term of office and be elected with and in the same manner as the President. He may be removed from office in the same manner as the President. So the Vice President may be appointed as a member of the Cabinet. Such appointment requires no confirmation. The President and the Vice President shall be elected by direct vote of the people for a term of 6 years, which shall begin at noon on the 30th day of June next following the day of the election, and shall end at noon of the same date 6 years thereafter. So the President shall not be eligible for any re-election. No person who has succeeded as President and has served as such for more than 4 years shall be qualified for election to the same office at any time. No Vice President shall serve for more than 2 successive terms. Voluntary renunciation of office for any length of time shall not be considered as an interruption in the continuity of the service for the full term for which he was elected. Unless otherwise provided by law, the regular election for President and Vice President shall be held on the second Monday of May. The returns of every election for President and Vice President, duly certified by the Board of Canvassers of each province or city, shall be transmitted to Congress, directed to the President of the Senate. Upon receipt of the certificate of canvass, the President of Senate shall not later than 30 days after the day of the election open all the certificates in the presence of the Senate and the House of Representatives in joint public session, and the Congress, upon determination of the authenticity and due execution thereof, in the manner provided by law, canvass the votes. The person having the highest number of votes shall be proclaimed elected, but in case 2 or more shall have an equal and highest number of votes, one of them shall forthwith be chosen by the vote of a majority of all the members of both houses of Congress, voting separately. So the Congress shall promulgate its rules for the canvassing of the certificates. The Supreme Court, sitting en banc, shall be the sole judge of all contests relating to the election, returns, and qualifications of the President and Vice President, and may promulgate its rules for the purpose. The president can serve for only 1 term, whereas the vice president, here it says that no vice president shall serve for more than 2 successive terms. Going back, what are the Question: What are the privilege afforded? What are the privilege afforded to the president and the vice president? So the following are their privileges. Number one, official residence for the president. Number two, salaries of the president and vice president are determined by law and not to be decreased during their tenure. Number three, presidential immunity. Immunity from suit during his tenure. Then number four, executive privilege has been defined as the right of the president and high-level executive branch officials to withhold information from Congress, the courts, and ultimately the public. So, question: What are the inhibitions and disqualifications imposed upon them? The following are the inhibitions and disqualifications under the law. Number one, shall have no increase in salaries during their tenure. Article 7, Section 6. Number 2, shall not receive any other emoluments from the government or any other source. Article 7, Section 6 of the Constitution. Number 3, shall not hold other office or employment unless otherwise provided in the Constitution. Article 7, Section 13. Number 4, shall not directly or indirectly practice any other profession, participate in any business, or be financially interested in any contract with or in any franchise or special privilege granted by the government or any subdivision, agency, or instrumentality thereof, including GOCCs or their subsidiaries. Article 7, Section 13. Strictly avoid conflict of interest in the conduct of their office. Article 7, Section 13. Number 6. May not appoint spouse or relatives by consanguinity or affinity within the fourth civil degree as members of constitutional commissions or the office of the ombudsman, or as secretaries, undersecretaries, chairman, or heads of bureaus or offices, including GOCCs and their subsidiaries. So, question: May former President Estrada be re-elected for president? The court did not rule on the matter. However, he was able to participate as a candidate for the position of president in May 10, 2010 elections, where he garnered the second highest number of votes, despite a petition for his disqualification, because no temporary restraining order was issued by the court. Since he was not elected president the second time he ran, and the issue of the proper interpretation of the phrase any re-election will be premised on a person's second election as president, there is no case or controversy to be resolved by the Supreme Court, no live conflict of legal rights. Pormento versus Estrada, August 2010. Question: Next topic, executive and administrative powers. Executive and administrative powers in general. Question: Distinguish executive power from administrative power. Executive power pertains to the power to enforce and administer the laws. It shall be vested in the President of the Philippines. Article 7, Section 1 of the Constitution. On the other hand, administrative power refers to the President's control over all executive departments, bureaus, and offices. He shall ensure that laws are faithfully executed. Article 7, Section 17. Question: What is the power of administrative reorganization? It is the President's continuing authority to reorganize the national government, which includes the power to group, consolidate bureaus and agencies, to abolish offices, to transfer functions, to create and classify functions, services, and activities, and to standardize salaries and materials. It is effected in good faith. If it is effected in good faith, it is for the purpose of economy or to make bureaucracy more efficient. Mewap versus Executive Secretary, July 31, 2007. Faithful Execution Clause. Faithful Execution Clause. The second sentence of Section 17, Article 7 is referred to as the take care power of the President, and also sometimes called the Faithful Execution Clause. Under this provision, the President is bound to ensure the faithful execution of the laws, regardless of his belief in the legality of said laws, until and unless a law is declared unconstitutional, the President has a duty to execute it, regardless of his doubts and as to its validity. Article 7, Sections 1 and 17 of the Constitution. So, faithful execution clause. The second sentence of Article 7 of Section 17, Article 7 is referred to as the take care power of the President and also sometimes called the faithful execution clause. Under this provision, the President is bound to ensure the faithful execution of laws, regardless of his belief in the legality of said laws. Until and unless a law is declared unconstitutional, the President has a duty to execute it, regardless of his doubts as to its validity. Next concept is the power of appointment. Define appointment. Answer. An appointment is the selection by the authority vested with the power to do so of an individual who will be tasked to exercise the functions of a given office. It differs from a designation in that the latter simply means the imposition of additional duties, usually by law, on a person already in the public service. It is also different from a commission, which refers to the written evidence of the appointment. Natura Supra at 356. So, an appointment is the selection by the authority vested with the power to do so of an individual, selection of an individual who will be tasked to exercise the functions of a given office. Whereas, the designation means the imposition of additional duties, usually by law, on a person already in public service. So designation, the person is already in public service, whereas in appointment, it is the selection of by the authority vested with the power to appoint of an individual who will be tasked to exercise the function of a given office. So the person is not yet in office. Person to be selected is not yet in office. Discuss the President's appointing power. So the President shall nominate, and with the consent of the Commission on Appointment, appoint the heads of the executive departments, ambassadors, other public ministers and consuls, or officers of the armed forces from the rank of colonel or naval captain, and other officers whose appointments are vested in him in this Constitution. He shall also appoint all other officers of the government whose appointments are not otherwise provided for by law, and those whom he may be authorized by law to appoint. The Congress may by law vest the appointment of the officers lower in rank in the President alone, in the courts, or in the heads of the departments, agencies, commissions, or boards. The President shall have the power to make appointments during the recess of Congress, whether voluntary or compulsory, but such appointments shall be effective only until disapproved by the Commission on Appointments or until the next adjournment of Congress. Article 7, Section 16 of the Constitution. What are the classification of appointments? What are the kinds of presidential appointments? So the following are the kinds of presidential appointments. Number 1, appointment made by an acting president. Number 2, this is Article 7, Section 14 of the Constitution. Number 2, midnight appointment. Appointment made by a president within 2 months before the next presidential elections and up to the end of his term. Then number 3, regular presidential appointments with or without confirmation by the Commission on Appointment, and recess or ad interim appointments. Article 7, Section 16 of the Constitution. Question: what are the appointments that can be made solely by the President? The following are such appointments. Number 1, those vested by the Constitution on the President alone. Number 2, those whose appointments are not otherwise provided for by law. Number 3, those whom he may be authorized by law to appoint. And number 4, those other officers lower in rank whose appointment is vested by law in the President alone. Article 7, Section 16 of the Constitution. Question. Can the President legally appoint officers in charge in the ARMM? Yes. The President shall appoint all other officers of the government whom the President may be authorized by law to appoint. Article 7, Section 16. Since the President's authority to appoint OICs emanates from RA number 10153, it falls under this group of officials that the President can appoint. Thus, the assailed law rests on a clear constitutional basis. Commission on Appointment Confirmation. So which presidential appointments require confirmation by the Commission on Appointment? Under the Constitution, the President shall nominate and with the consent of the Commission on Appointment, appoint number 1, heads of executive departments, Article 7, Section 16 of the Constitution. Number 2, ambassadors and other public ministers and consuls, Article 7, Section 16. Number 3, officers of the AFP from the rank of colonel or naval captain, Sarmiento versus Mison, December 17, 1987. Number 4, officers whose appointments are vested in him by the Constitution. Regular members, these are the regular members of the Judicial and Bar Council, Article 8, Section 8, Paragraph 2 of the Constitution. Letter B, chairman and members of the Constitutional Commissions, Article 9-B, Section 1, Paragraph 2 of the Constitution. And letter C, sectoral representatives, Quintos Delis versus Commission on Appointments, September 1989. Question. What are the appointments that do not need confirmation from the Commission on Appointments? So the following are the appointments that need no confirmation from the Commission. Number 1, members of the Supreme Court and judges of lower courts. Number 2, this is Article 8, Section 9. Number 2, Ombudsman and his deputies. Article 11, Section 9 of the Constitution. Number 3, Commissioner of Customs. Sarmiento versus Mison, December 1987. Number 4, Chairman of the Commission on Human Rights, Bautista versus Salonga, April 1989. And 5, appointments and promotions in the Philippine Coast Guard. Appointments and promotions in the Philippine Coast Guard, Soriano versus Lista, March 2003. What is the procedure for appointment that need the confirmation of the Commission on Appointment? So the procedure is as follows. Number 1, nomination by the President. Number 2, confirmation by the Commission on Appointment. Number 3, issuance of commission. Number 4, acceptance by the appointee. Lacson versus Romero. Question. What is a bypassed appointment? A bypassed appointment is one that has not been finally acted upon on the merits of the Commission on Appointment. At the close of the session of the Congress, there is no final decisions by the Commission on Appointments to give or withhold its consent to the appointment as required by the Constitution. Matibag versus Benipayo. Bypassed appointment. Bypassed appointment is one that has not been finally acted upon on the merits by the Commission on Appointment at the close of the session of Congress. There is no final decision by the Commission on Appointments to give or withhold its consent to the appointment as required by the Constitution. Matibag versus Benipayo, April 2002. Question. What are the effects of a bypassed appointment? Nominations or appointments submitted by the President of the Philippines which are not finally acted upon at the close of the session of Congress shall be returned to the President, and unless new nominations or appointments are made, shall not again be considered by the Commission on Appointment. Rules of Commission on Appointment. A bypass appointment can be considered again if the President renews the appointment. Matibag versus Benipayo, April 2002. Again, bypassed appointment. Etong bypassed appointment is one that has not been finally acted upon on the merits by the Commission on Appointments at the close of the session of Congress. So the session of the Congress is closed, but the appointment has not been acted upon on the merits by the Commission on Appointment. So there is no final decision by the Commission on Appointment to give or withhold its consent to the appointment as required by the Constitution. Then what are the effects of a bypassed appointment? Nomination or appointment submitted by the President of the Philippines which are not finally acted upon. So if it is bypassed, if it is not acted upon at the close of the session of Congress, then um, such uh, such uh, such appointment shall be returned to the President, and unless a new nomination or appointments are made, shall not again be considered by the Commission on Appointment. A bypass appointment can be considered again if the President renews the appointment. So, unless the President renews the appointment, a bypass appointment cannot be considered again. Matibag versus Benipayo. Midnight appointment. What are midnight appointments? Midnight appointments are appointments made by the president within 2 months before the next presidential elections and up to the end of his term. So within 2 months, so the appointment is made within 2 months before the presidential elections and up to the end of his term. So this is called a midnight appointments. Is the prohibition on midnight appointments absolute? No. The president or acting president may make temporary appointments to executive positions which continued vacancies therein will prejudice public service or endanger public safety. Article 8, Section 15 of the Constitution. Question. Does the prohibition apply to the appointments made by the President in the judiciary? No, the prohibition on midnight appointments does not apply to appointees to the judiciary. The fact that Section 14 and 16, Article 7 refer only to appointments within the executive department renders conclusive that Section 15 also applies only to the executive department. The framers did not need to intend the prohibition to appointments in the judiciary because their establishment of the GBC and their subjecting the nomination and screening of candidates for judicial positions to unhurried and deliberate prior process of the JBC ensured that there would no longer be midnight appointments to the judiciary. So, again, does the prohibition apply to the appointments made by the President in the judiciary? No. The prohibition on midnight appointments does not apply to appointees to the judiciary. So the fact that Section 14 and 16, Article 7 refer only to appointments within the executive department renders conclusive that Section 15 also applies only to the executive department. The framers did not need to extend the prohibition to appointments in the judiciary because their establishment of the JBC and their subjecting the nomination and screening of candidates for judicial positions to the unhurried and deliberate prior process of JBC ensured that there would no longer be midnight appointments to the judiciary. De Castro versus Judicial and Bar Council, March 17, 2010. So the prohibition on midnight appointments does not midnight appointment does not apply to appointees to the judiciary. Power of removal. What are the rules on the President's power of removal? The general rule is that from the express power of appointment, the President derives the implied power of removal. Exception to this rule are those appointed by him where the Constitution prescribes certain methods of separation for public service, example, impeachment under Section 2, Article 11, 1987 Constitution. So in cases where the power of removal is lodged in the President, the same may be exercised only for causes as may be provided by law and in accordance with the prescribed administrative procedure. So the President may directly discipline the members of the career service of civil service who are appointed by him. Villaluz versus Saldivar, December 1965. So the general rule is that from the express power of appointment, the President derives the implied power of removal. So in cases where the power of removal is lodged in the President, the same may be exercised only for causes as may be provided by law and in accordance with the prescribed administrative procedure. Question: who are regular appointees? Regular appointees are those appointed by the President while Congress is in session. Then, what are ad interim appointees? Ad interim appointees are those appointed by the President while Congress is not in session. So, if it is appointed by the President while Congress is in session, they are called regular appointees. If they are appointed by the President while Congress is not in session, then they are called ad interim appointees. Distinguish regular appointees from ad interim appointees. A regular appointment is one made by the President while Congress is in session after the nomination is confirmed by the Commission on Appointments and continues until the end of the term. An ad interim appointment is one made while Congress is not in session before confirmation of the Commission on Appointments is immediately effective and ceases to be valid if disapproved or bypassed by the Commission on Appointments upon the next adjournment of Congress. Question. Again, ad interim appointment is one made while Congress is not in session before confirmation of the Commission on Appointments. So there is no confirmation of the Commission on Appointments yet, and therefore it is immediately effective and ceases to be valid. It is immediately effective but ceases to be valid if disapproved or bypassed by the Commission on Appointment. Again, what is a bypassed appointment? A bypassed appointment is one that has not been acted upon by the Commission on Appointment at the close of the session of Congress. Question: what is the purpose of an acting appointment? The essence of an appointment in an acting capacity is its temporary nature. It is a stopgap measure intended to fill an office for a limited time until the appointment of a permanent occupant to the office. Pimentel versus Ermita, October 2005. Question: can the President issue an acting appointment? Yes. The Administrative Code provides that the President may temporarily designate an officer already in the government service or any other competent person to perform the functions of an office in the executive branch appointment to which is vested in him by law, when the officer regularly appointed to the office is unable to perform his duties by reason of illness, absence, or any other cause, or there exists a vacancy. Although there is a distinction between an appointment and a designation, Benamira versus Garucho, July 1990, it was not applied in the case of Pimentel versus Ermita, which upheld the President's power to issue an acting appointment. The reason is because the Code allows any other competent person to be designated. So, the purpose of the acting appointment is its temporary nature. It is a stopgap measure intended to fill an office for a limited time until the appointment of a permanent occupant of the office. Can President issue an acting appointment? Yes. The Administrative Code provides that the President may temporarily designate an officer already in government service or any other competent person to perform the functions of an office in the executive branch appointment to which is vested in him by law. So the officer regularly appointed to the office is unable to perform his duties by the reason of illness, absence, or any other cause, or there exists a vacancy. Question: what is the difference between ad interim appointments and acting appointments? So both of them are effective upon acceptance, but ad interim appointments are extended only during a recess of Congress, whereas acting appointments may be extended anytime there is vacancy. Moreover, ad interim appointments are submitted to the Commission on Appointments for confirmation or rejection. Acting appointments are not submitted to the Commission on Appointments. Acting appointments are a way of temporary filling important offices, but if abused, they can also be a way of circumventing the need for confirmation by the Commission on Appointments. Pimentel versus Ermita. Again, the difference between ad interim appointments and acting appointments. So both of these appointments, ad interim and acting appointments, are effective upon acceptance. But ad interim appointments are extended only during a recess of Congress, whereas acting appointments may be extended at any time there is a vacancy. Ad interim appointments are submitted to the Commission on Appointment for confirmation or rejection. Acting appointments are not submitted to the Commission on Appointments. Acting appointments are a way of temporary filling important offices, but if abused, they can always be a way of circumventing the need for confirmation by the Commission on Appointments. Pimentel versus Ermita. Next concept, power of control and supervision. Distinguish control from supervision. Control is the power of an officer to alter or modify or nullify or set aside what a subordinate officer had done in the performance of his duties and to substitute the judgment of the former for that of the latter. On the other hand, supervision is the power or authority of an officer to see that subordinate officers perform their duties, and if the latter fail or neglect to fulfill them, then the former may take such action or steps as prescribed by law. Mondaña versus Silvosa, May 1955. So, distinguish control from supervision. Control is the power of an officer to alter or modify or nullify or set aside what a subordinate officer had done in the performance of his duties and to substitute the judgment of the former for that of the latter. On the other hand, the so-called supervision is the power or authority of an officer to see that the subordinate officers perform their duties, and if the latter fail or neglect to fulfill them, then the former may take action or steps as prescribed by law. Mondaña versus Silvosa. Doctrine of qualified political agency. The doctrine of qualified political agency. All executives and administrative organizations are adjuncts of the executive department. The heads of the various executive, and except in cases where the chief executive is required by the Constitution or law to act in person or on or the exigencies of the situation demand that he acts personally, the multifarious executive and administrative functions of the chief executive are performed by and through the executive departments, and the acts of the secretaries of executive departments, when performed and promulgated in the regular course of business, are, unless disapproved or reprobated by the chief executive, presumptively the acts of the chief executive. Thus, the executive secretary, when acting by authority by the president, may reverse the decision of another department secretary. Lacson Magallanes versus Pano, November 1967. The decision of the cabinet secretary carries the presumptive approval of the president, and there is no need to appeal the decision to the president in order to complete exhaustion of administrative remedies. Kilusang Bayan et al. Versus Dominguez. Again, discuss the doctrine of qualified political agency. So, all executives and administrative organizations are adjuncts to the executive department. The heads of the various executives, and except in cases where the chief executive is required by the Constitution or law to act in person or the exigencies of the situation demand that he acts personally, the multifarious executive and administrative functions of the chief executive are performed by and through the executive departments, and the acts of the secretaries of executive departments, when performed and promulgated in the regular course of business, or unless disapproved or reprobated by the chief executive, are presumptively the acts of the chief executive. This is Villena versus Secretary of the Interior. Thus, the executive secretary, when acting by authority of the president, may reverse the decision of another department secretary. So, the decision of the cabinet secretary carries the presumptive approval of the president, and there is no need to appeal the decision to the president in order to complete exhaustion of administrative remedies. Kilusang Bayan et al. Versus Dominguez, January 1992. Next, executive department and offices. Thus, the president exercises power of control over the executive department and offices. Yes, the president shall have control of all executive departments, bureaus, and offices. This is under Article 7, Section 17 of the Constitution. Local government units. Discuss the power of the president to supervise local government units. The President of the Philippines shall exercise general supervision over local governments. The President may only interfere in the affairs and activities of a local government if he or she finds that the latter had acted contrary to law. The Dole versus Commission on Audit. So the President of the Philippines shall exercise general supervision over local governments. Article 10, Section 4 of the Constitution. The President may only interfere in the affairs and activities of the local government unit if he or she finds that the latter had acted contrary to law. The Dole versus Commission on Audit, December 2002. Next concept, emergency powers. What emergency powers may be delegated to the President? Answer. Congress may authorize the President to exercise powers necessary and proper to carry out a declared national policy. It is submitted that, on the basis of this provision, the President may be given emergency legislative powers if Congress so desires. This is confirmed by the explanation made on the floor of the 1971 Convention, which is the source of this provision, that emergency powers can include the power to rule by executive fiat, Bernas Supra. So, Congress may authorize the President to exercise powers necessary and proper to carry out a declared national policy. So muna siya yung ito yung emergency powers niya. It is submitted that on the basis of this provision, the President may be given emergency legislative powers if Congress so desires. So what provision? Congress may authorize the President to exercise powers necessary and proper to carry out a declared national policy. Question: what is the reason behind the exercise of emergency powers? Generally, Congress is the repository of emergency powers. This is evident in the tenor of Section 23, Article 6, authorizing it to delegate such powers to the President. Certainly, a body cannot delegate a power not reposed upon it. However, knowing that during grave emergencies it may not be possible or practicable for Congress to meet and exercise its powers, so the framers of the Constitution deemed it wise to allow Congress to grant emergency powers to the President subject to certain conditions. David versus Arroyo. So the reason behind the exercise of emergency powers is that knowing that during grave emergencies, if there are grave emergencies, it may not be possible or practicable for Congress to meet and exercise its powers. So the framers of the Constitution deemed it wise to allow Congress to grant emergency powers to the President subject to certain conditions. Question: what is the duration of the emergency powers vested to the President? So such powers shall cease upon the next adjournment of Congress unless sooner withdrawn by resolution of the Congress. So it shall cease upon the next adjournment of Congress unless sooner withdrawn by resolution of the Congress. Article 6, Section 23. Article 6, Section 23 of the 1987 Constitution. Question: is there a difference between national emergency and state of emergency relative to the exercise of emergency powers by the President? Answer: in the case of Ampatuan versus Puno, the Supreme Court had occasion to explain this. The court clarified that the deployment by then President Gloria Macapagal Arroyo of the AFP and the PNP is not itself an exercise of emergency powers, as understood in Section 23, Paragraph 2, Article 6 of the Constitution. She did not act pursuant to any law enacted by Congress that authorized her to exercise extraordinary powers. The President did not proclaim national emergency, only a state of emergency in three certain places in the exercise of her calling out power under the Constitution. June 7, 2011. Question: differentiate emergency powers from calling out power of the President. The calling out of the armed forces to prevent or suppress lawless violence is a power that the Constitution directly vests in the President. The President does not need a congressional authority to exercise the same. Ampatuan versus Puno, June 2011. While emergency powers is the power vested by the Congress to the President to exercise powers necessary and proper to carry out a declared national policy during a state of war or national emergency, there must be a law authorizing the President to exercise such power. Again, differentiate the calling out emergency powers from calling out power of the President. So the calling out power of the armed forces, the calling out of the armed forces to prevent or suppress lawless violence is a power that the Constitution directly vests in the President. The President does not need a congressional authority to exercise the same. So, sa calling out powers, since it is vested by the Constitution to the President does not need a congressional authority to exercise the same. While the emergency powers is the power vested by the Congress to the President to exercise powers necessary and proper to carry out a declared national policy during a state of war or national emergency, there must be a law authorizing the President to exercise such power. Article 7, Section 18 of the 1987 Constitution empowers the President of the Republic to declare martial law for a period not exceeding 60 days in cases of rebellion and invasion when public safety requires it. Limitations and or the President shall be the commander. The President shall be the commander-in-chief of all armed forces of the Philippines, and whenever it becomes necessary, he may call out such armed forces to prevent or suppress lawless violence, invasion, or rebellion. In case of invasion or rebellion, when the public safety requires it, he may, for a period not exceeding 60 days, suspend the writ of habeas corpus or place the Philippines or any part thereof under martial law. Within 48 hours from the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus, the President shall submit a report in person or in writing to Congress. The Congress, voting jointly by a vote of at least a majority of all its members in regular or special session, may revoke such proclamation or suspension, which revocation shall not be set aside by the President. Upon the initiative of the President, the Congress may, in the same manner, extend such proclamation or suspension for a period to be determined by Congress. If the invasion or rebellion shall persist and public safety requires it, the Congress, if not in session, shall within 24 hours following such proclamation or suspension convene in accordance with its rules without any need of a call. The Supreme Court may review in an appropriate proceeding filed by any citizen the sufficiency of the factual basis of the proclamation of martial law, or the suspension of the privilege of the writ, or the extension thereof, and must promulgate its decision thereon within 30 days from its filing. A state of martial law does not suspend the operation of the Constitution, nor supplant the functioning of the civil courts or legislative assemblies, nor authorize the conferment of jurisdiction on military courts and agencies over civilians where civil courts are able to function, nor automatically suspend the privilege of the writ. So the suspension of the privilege of the writ shall apply only to persons judicially charged for rebellion or offenses inherent in or directly connected with the invasion. During the suspension of the privilege of the writ, any person thus arrested or detained shall be judicially charged within 3 days, otherwise he shall be released. Article 7, Section 18 of the 1987 Constitution. Pardoning power. Nature and limitations. Discuss the nature of the pardoning power of the President. So the exercise of the pardoning power is discretionary in the President and may not be interfered with by Congress or the court, except only when it exceeds the limits provided for by the Constitution. Resos Vidal versus Comelec, January 2015. In granting the power of executive clemency upon the President, Article 7 of the Constitution does not distinguish between criminal and administrative cases. Llamas versus Executive Secretary, October 1991. Except in cases of impeachment or as otherwise provided in the Constitution, the President may grant reprieves, commutations, and pardons, and remit fines and forfeitures after conviction by final judgment. He shall also have the power to grant amnesty with the concurrence of a majority of all the members of Congress. Question: what are the limitations of the pardoning power of the President? So the following are the limitations to said power. Number 1, it cannot be granted in cases of impeachment. Article 7, Section 19 of the Constitution. Number 2, cannot be granted in violations of election laws without the favorable recommendation of the COMELEC. Article 9-C, Section 5 of the Constitution. Number 3, can be granted only after conviction by final judgment, except amnesty. The President grants amnesty, it should be done with the concurrence of a majority of all the members of Congress. Limitation on the pardoning power of the President is number 4. It cannot be granted in cases of legislative contempt or civil contempt. Number 5. It cannot absolve convict of civil liability. Number 6. Cannot restore public offices forfeited. Number 7. A grant of amnesty must be with the concurrence of a majority of all the members of Congress. Article 7, Section 19 of the Constitution. Forms of executive clemency. What is pardon? Pardon is an act of grace which exempts an individual on whom it is bestowed from punishment, which the law inflicts for a crime he has committed. A pardon is a deed for the validity of which delivery is essential, and delivery is not complete without acceptance, so it can be rejected. U.S. versus Wilson. So, ang pardon is a deed. Since it is a deed for the validity of which delivery is essential, and delivery is not complete without acceptance, it can be rejected. What are the classification of pardon? Pardon may be classified as follows: 1. Conditional pardon, and 2. Absolute pardon. Conditional pardon. In the nature of a contract between the chief executive and the convicted criminal, by the pardonee's consent to the terms stipulated in the contract, the pardonee has placed himself under the supervision of the chief executive or his delegate, who is duty-bound to see to it that the pardonee complies with the conditions of the pardon. Torres versus Gonzalez, July 1987. So, conditional pardon. In the nature of a contract between the chief executive and the convicted criminal, by the pardonee's consent to the terms stipulated in the contract, the pardonee has placed himself under the supervision of the chief executive or his delegate, who is duty-bound to see to it that the pardonee complies with the conditions of the pardon. Torres versus Gonzalez. Absolute pardon. Pardon is absolute if it is not only unconditional. If it is not only unconditional, it is also unrestricted in scope, complete and plenary in character. Rizos Vidal versus Comelec, January 2015. Absolute. Pardon is absolute if it is not only unconditional, it is also unrestricted in scope, complete and plenary in character. Conditional pardon in the nature of a contract between the chief executive and the convicted criminal. So, by the pardonee's consent to the terms stipulated in the contract, the pardonee has placed himself under supervision of the chief executive or his delegate, who is duty bound to see to it that the pardonee complies with the conditions of the pardon. Question: what is amnesty? Amnesty is an act of grace by the President, concurred in by the legislature, usually extended to classes of persons or communities who may be guilty of political offenses, generally before or after the institution of the criminal prosecution and sometimes after conviction. It looks backward and abolishes and puts into oblivion the offense itself that the person released and that the person is released by amnesty stands before the law precisely as though he had committed no offense. Baroquinto versus Fernandez, January 20, 1949. What are the other forms of executive clemency? Question. The other forms of executive clemency are the following. Number 1, commutation, which is the reduction or mitigation of the penalty. Number 2, reprieve, which is the postponement of sentence to a date certain or stay of execution. Number 3, parole, release from imprisonment but without full restoration of liberty, as parolees is in the custody of the law although not in confinement. And number 4, remission of the fines and forfeiture, merely prevents the collection of fines or the confiscation of forfeited property. It cannot have the effect of returning the property which has been vested in third parties or money already in public treasury. So the other forms of executive clemency are commutation, the reduction or mitigation of the penalty; reprieve, which is the postponement of sentence to a date certain; parole, which is the release from imprisonment, but without full restoration of liberty, as parolee is in the custody of the law, although not in confinement. And number 4, remission of fines and forfeitures, merely prevents the collection of fines or the confiscation of forfeited property. Next concept is foreign relations power, diplomatic power. Discuss the diplomatic power of the president. So the president is the sole organ of the nation in its external relations and its sole representative with the foreign nations. Neri versus Senate, September 2008. So is a treaty of international agreement entered into by the president valid and binding in itself? No. No treaty or international agreement shall be valid and effective unless concurred in by at least two-thirds of all the members of Senate. This is Article 7, Section 21 of the Constitution. No treaty or international agreement shall be valid and effective unless concurred in by at least two-thirds of all the members of Senate. So the power to ratify is vested in the President, subject to the concurrence of the Senate. The role of Senate, however, is limited only to giving or withholding its consent or concurrence to the ratification. Hence, it is within the authority of the President to refuse to submit a treaty to the Senate or, having secured its consent for ratification, refuse to ratify it. Pimentel Jr. versus Office of the Executive Secretary, July 2005. The concurrence of said House of Congress is required by our fundamental law in the making of treaties, which are however distinct and different from executive agreements, which may be validly entered into without such concurrence. Commissioner of Customs versus Eastern Sea Trading, October 1961. Question: what are the other foreign affairs powers granted to the President? So the following foreign affairs powers are also vested to the President. Number 1, the power to make treaties. Number 2, the power to appoint ambassadors, other public ministers, and consuls. And number 3, the power to receive ambassadors and other public ministers duly accredited to the Philippines. Question: what are the differences between a treaty and an executive agreement? So a treaty as an international agreement concluded between states is in written between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. So, an executive agreement is similar to a treaty except that the former does not require legislative concurrence, is usually less formal, and deals with a narrower range of subject matter. So, a treaty as an international agreement is concluded between the states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. Whereas an executive agreement is similar to a treaty except that the former does not require legislative concurrence, is usually less formal, and deals with a narrower range of subject matters. International agreements involving political issues or changes of national policy, and those involving international arrangements of a permanent character usually take the form of treaties, but international agreements embodying adjustments of detail, carrying out well established national policies and traditions, and those involving arrangements of a more or less temporary nature usually takes the form of executive agreements. Question: can the President enter into an executive agreement without the concurrence of Senate? Yes. The right of the executive to enter into binding agreements without the necessity of subsequent congressional approval has been confirmed by long usage. From the earliest days of our history, we have entered into executive agreements covering such subjects as commercial and consular relations, most favored nation rights, patent rights, trademark and copyright protection, postal and navigational arrangements, and the settlement of claims. The validity of these have never been seriously questioned by our courts. Bayan Muna versus by Ocampo Beltran and Maza versus Alberto Romulo, February 2011. Powers relative to appropriation measures. Question: what are the powers granted to the President in relation to appropriation measures that may be taken? The following are the powers granted to the President relative to appropriation measures. 1. The President shall submit to the Congress within 30 days from the opening of every regular session, as the basis of the General Appropriations Bill, a budget of expenditures and sources of financing, including receipts from existing and proposed revenue measures. Article 7, Section 22 of the Constitution. Number 2. The President may by law be authorized to augment any item in the General Appropriations Law for their respective offices from savings in other items of their respective appropriation. Article 6, Section 25, Paragraph 5 of the Constitution. And number 3, the President shall have the power to veto any particular item or items in an appropriation, revenue, or tariff bill, but the veto shall not affect the item or items to which he does not object. So, item veto. The President shall have the power to veto any particular item or items in an appropriation, revenue, or tariff bill, but the veto shall not affect the item or items to which he does not object. Article 6, Section 27, Paragraph 2 of the Constitution. Validity of transferring savings between departments. What is the rule on transfer of appropriation? So as a general rule, no law shall be passed authorizing any transfer or appropriations. However, the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of the constitutional commissions may by law be authorized to augment any item in the General Appropriation Law for their respective offices from savings on other items of their respective appropriations. Article 6, Section 25, Paragraph 5 of the Constitution. So the Supreme Court in the Philippine Constitution Association versus Enriquez upheld the presidential veto of a provision which authorized the Chief of Staff to use savings to augment the pension fund on the ground that under Section 25, Paragraph 5, Article 6, such right must and can be exercised only by the President of the Philippines. Presidential veto and congressional override. So discuss the rules on presidential veto. The general rule is that the president must approve entirely or disapprove in toto. The exception to this rule is in case of appropriation, revenue, and tariff bills where item veto is allowed. However, there are exceptions to this exception, namely, so the exception to item veto rule is that number 1, doctrine of inappropriate provisions. Number 2, executive impoundment. So a provision that is constitutionally inappropriate for an appropriation bill may be singled out for veto even if it is not appropriation or revenue bill. So even if it is not an appropriation or revenue bill, it may be singled out for veto if the provision is inappropriate. So doctrine of inappropriate provision. Number 2, executive impoundment. So refusal of the president to spend funds already allocated by Congress for a specific purpose. It is the failure to spend or obligate budget authority of any type. Felconsa versus Enriquez, August 1994. So discuss the rules on congressional override. If the president exercises his power to veto, he must return the bill with his objections to the House where it originated, which shall enter the objections at large in its journal and proceed to reconsider it. The House may either 1. Take into account the objections made by the president and make corresponding amendments in the bill. The bill as amended will again be presented to the president for his approval. Or number 2, invalidate the veto and convert the bill into law over the objection of the president when concurred by the vote of 2/3 of all members of each house. So, rules on congressional override. If the president exercises his power to veto, so if the president vetoes a bill, he must return the bill with his objections to the House where it originated. Return the bill with objections to the House where it originated, which shall enter the objections at large in its journal and propose to reconsider it. So what the House will do is that it will take into account the objections made by the President and make a corresponding amendment in the bill. The bill as amended will again be presented to the President for his approval. The House can also invalidate the veto and convert the bill into law over the objection of the President, when concurred by the vote of 2/3 of all its members of each House. So even without the approval of the President, even with the objection of the President, the Congress may still convert the bill into law by by vote of 2/3 of all the members of each house. So invalidate the veto and convert the bill into law over the objection of the president when concurred by 2/3 of all its members. So when must the president communicate his veto? The president shall communicate his veto of any bill to the House where it originated within 30 days after the date of receipt thereof. Otherwise, it shall become a law, as if he had signed it. What is pocket veto? So vetoing a bill by an executive by not acting in the time given by law. An invalid veto is without effect. Example, it is as if the president did not act on the bill at all. Hence, the bill becomes a law by executive inaction. Article 7, Section 20 of the 1987 Philippine Constitution says, the President may contract or guarantee foreign loans on behalf of the Republic of the Philippines with the prior concurrence of the Monetary Board and subject to such limitations as may be provided by law. The Monetary Board shall within 30 days from the end of every quarter of the calendar year submit to the Congress a complete report of its decision and application for loans to be contracted or guaranteed by the government or government-owned and controlled corporations, which would have the effect of increasing the foreign debt and containing other matters as may be provided by law. So, The President may contract, guarantee foreign loans on behalf of the Republic of the Philippines with the prior concurrence of the Monetary Board and subject to such limitations as may be provided by law. So the Monetary Board shall within 30 days from the end of every quarter of the calendar submit to the Congress a complete report of its decision on the application for loans to be contracted or gathered by the government or government-owned and controlled corporation, which would have the effect of increasing the foreign debt and containing other matters as may be provided by law.